Good afternoon, everybody. Thanks for joining us for today's webinar, Property Predicament, the Power of Eminent Domain. Before we get started, if you have a question at any time during the webinar, please type it in the Q&A question box that's located in your Zoom control panel, and we'll address them at the end of today's presentation if there's time. Our presenter today is Joseph Morrison. He's a litigation attorney here at Kelleher and Holland. He's been practicing for over 4 decades, focusing on complex business, personal injury, and real estate cases. Joe's tried dozens of eminent domain cases involving millions of dollars in verdicts, so he is well versed to talk about today's topic. So, Joe, I will turn it over to you to educate us all about eminent domain.
Thanks, Amy. Thanks for the introduction. Also, thanks for all your help in putting this webinar together. Eminent domain is known as the taking of private property for public use. And you'll note in that definition that what is eminent domain? Eminent domain is the government's power to acquire private property for a public use without the owner's consent. Note that there's no provision in the definition of eminent domain itself of compensation, of just compensation. Eminent domain comes from England, and where the king would acquire property for his own uses and would sometimes pay the owners and sometimes would not. Our founding fathers said, wait a minute, that's not fair. And so they put an amendment to the U.S. Constitution. Next slide, please, Amy. The U.S. Constitution and the Fifth Amendment provides that private property cannot be taken for a public use unless you pay just compensation. So just compensation became a critical part of eminent domain proceedings as a result of this amendment to the U.S. Constitution. The Illinois Constitution has a very similar provision, but it differs in a couple of respects. First of all, it says private property shall be taken or damaged. And that or damaged part seems to suggest, and there are some Illinois cases that have held this, that if a piece of property is damaged as a result of actions by the government, you can have a claim for compensation even if there is no taking. The constitutional limits on the power of eminent domain is, first of all, the government has to have the power. It's inherent in the federal government and in state government. But local governments depend upon a specific grant of power from the Illinois legislature in order to exercise eminent domain. And there may be some limits upon the powers that the state places on certain municipalities. For example, forest preserves have the condemnation power, the right to acquire private property for a public use by paying just compensation. But they can't acquire property for any purpose. They can only acquire it for open space and other types of forest preserve uses. The use must be a public use, and it must be for a public purpose. So, for example, IDOT acquires right away for roads. That's certainly a public purpose. Municipalities acquire land for public buildings. Again, clearly a public purpose. Forest preserves acquire land for open space. Clearly, again, the legislature has determined that that is a proper public purpose. But of course, the government has to pay just compensation if it files an action in eminent domain, otherwise called condemnation. Condemnation is really an eminent domain action filed to have the jury decide the just compensation. So we talked about who can exercise the power of eminent domain. Certainly the federal government can, state can, municipalities can. But again, the power to the local government must be strictly construed. The question then becomes, what about private corporations? Certain private corporations, such as public utilities, have been granted the right of eminent domain. Railroads have also historically had the power of eminent domain. It used to be that both railroads and public utilities would have to get the consent of the Illinois Commerce Commission before filing eminent domain. They would file a petition with the Commerce Commission stating what land they wish to acquire and why it was needed and why it couldn't be acquired without eminent domain, and then get the consent of the Illinois Commerce Commission to file that action. Still a requirement for public utilities, but no longer a requirement for railroads. The big issue in eminent domain in the last few decades has been, what is a public use? Typically, public uses we've talked about: roads, public buildings, preserved natural areas such as parks or forest preserves, schools, police departments. The typical type of use where the government acquires the land, the public body becomes the owner of the land, and the public body keeps title to the land. That's typically what's found in many eminent domain cases. But in the 20th century, the concept of public use was tested. It became a use of power by local governments when they were doing a redevelopment project, and they would have a private developer that they were working with. A lot of times they had a contract or an agreement with that private developer to redevelop the property in accordance with the plan that had been approved by the city or municipality. The problem, of course, is that some of the owners within the development say, no, we're not selling. Then the developer would go to the municipality and say, wait a minute, I can't get this guy to sell his land, so we need to file an action in eminent domain. And they would file that action in eminent domain. It began in the 1930s and 40s with the elimination of what the courts have called slum or blighted areas. In the case of City of Chicago versus Zwick, Z-W-I-C-K, 27 Illinois 2nd, 128. In 1963, the Illinois Supreme Court reaffirmed the power of public bodies to acquire land for the elimination of blight or slums. But in these areas, a lot of times the government would keep title to the property and then build public housing or something like that. And then, of course, it advanced to the point where the private developer will end up with the title to the property. The courts in those slum and blighted cases talked about how the use would affect the community and what public benefits would come from that acquisition, and really didn't focus on the end user and who the end user would be. But then there was Southwestern Illinois Development Authority versus National City Environmental, 199 Illinois 2nd, 225. In this case, Southwest Illinois Development Authority filed the condemnation action at the request of request of the owner of a racetrack, which had been financed in part with funds from SWIDA, that they needed land for on additional parking. And the neighbor NCI, National City Environmental, wouldn't sell, so the city then filed the condemnation case. This was a case in which the government was exercising its power at the request of a private developer, so that that private developer could end up with title to the real estate. The Supreme Court held that this type of use of government eminent domain power was essentially for a private purpose, not a public purpose. The racetrack was a private venture. It was designed to make profits. And so the court held that there was really a minimal public benefit and that the real benefit was to a private owner, and that was an abuse of the eminent domain power. Contrast that with Kelo versus City of New London. In the Kelo versus City of New London case, that's a U.S. Supreme Court case, 549 U.S. 469. In that case, the city of Kelo had a redevelopment plan that exercised the power of eminent domain against certain owners that wouldn't sell. Those owners filed a lawsuit against the city of New London, claiming that their Fifth Amendment rights were being violated. In that case, the U.S. Supreme Court held that a carefully formulated economic development plan was a proper public purpose, even though the end result was that a private developer would own the property. This case differs, of course, from Southwestern Illinois case that we talked about previously, was because the city was doing it as a result of a redevelopment plan. And this plan had been publicly discussed, debated, and adopted. And the U.S. Supreme Court found that that was very significant. And it seemed to indicate that as long as the city or carefully developed redevelopment plan, the taking would be proper. Now we have the city of Chicago versus Eichner case in 2015, in which the city of Chicago was doing the same thing. It had a plan. It was developing some land for industrial purposes. It needed Mr. Eichner's land to follow an eminent domain suit, which Mr. Eichner challenged. And the Illinois Supreme Court ultimately held, I think it was an appellate court case. The appellate court held that the condemnation for private development may be allowed as a sound public use in the context of economic redevelopment. But the key again was that this was an overall development plan that was being, and that was the development plan was the public benefit that allowed the city to exercise its power of eminent domain. In response, it was a big public outcry after Kelo, and the courts have sort of narrowed Kelo. But Illinois adopted the Eminent Domain Act, a substantial revision to the Illinois Eminent Domain Code in 2007. And one of the significant things that it did was it addressed Kelo. And it created categories of takings. And these categories of takings ended up with different standards that you had to follow. So if you were acquiring property for public ownership and control, there was no additional standards that were put in other than the regular standards that it must be for a proper public use. This was a proper public use. Acquiring land for acquiring blighted property for private ownership and control is another category under the statute, which again provides different standards if you're going to try to exercise power of eminent domain for that purpose. And then for the Kelo example, where you're acquiring private development and control, but the property is not blighted necessarily, but it's being done for redevelopment purposes. The standard is you have to have clear and convincing evidence that the redevelopment is necessary. It also requires the payment of relocation costs, which were not required previously in Illinois for just a state taking. We'll get into relocation costs in a minute. So there are different standards that the Illinois Eminent Domain Act put into place to try to address what some felt was an abuse of the eminent domain power by simply allowing a private developer to come in, request eminent domain case, government would come in, acquire the property, and then give it to the developer. If you're going to do that now in Illinois, you have to read the statute carefully because there are now different standards that you have to meet in order to exercise that power. So when an attorney is hired by a public body to acquire property and is hired to file the eminent domain case, the attorney has to ask several questions. First of all, does the plaintiff have the authority to take it? Does they have statutory authority to acquire the land? And you might have to even read this. Sometimes you have to even read the statute to find out. But most of the time, that's self-evident. Second, does the plaintiff have the right to acquire this particular property? In other words, has the public body taken the necessary preliminary steps the law requires a public body to take before it can exercise the power of eminent domain? So you have to look at all of those steps and make sure they've all been complied with. One of the things you would look at very carefully is the legal description of the land sought to be acquired, and I always require a public body to give me a plat, a survey, or at least a plat of the property, so I can see what they're acquiring and the legal description matches what they're acquiring. Because if the legal description is wrong, your complaint for condemnation can be dismissed. And then, of course, how much compensation are we dealing with? And what kind of experts are you ultimately going to need? But for the filing of the condemnation case, you just need to know that an offer was made and the owner did not agree. If an eminent domain case is filed, there are two issues in an eminent domain case once it's filed. The first issue, does the public body have the right to take the property? That is decided, if challenged by the owner, that is decided by the judge. The court decides that issue. The way to bring that, and the second issue, of course, is the amount of just compensation, which is typically done by a jury. So for the first issue, if an owner wishes to challenge the right to take, the owner files a document. It's called a traverse. Traverse is an old English term that means put you to your proof. So the grounds for a traverse are, some of them anyway, the taking is not for a proper public purpose. The taking isn't necessary. They don't need this land. They already have enough land to do what they need to do. Did the public body make a bona fide attempt to agree? A lot of times in a traverse, that's challenged. And we'll talk about that in a minute. We've talked about the legal description possibly being inaccurate. And then, of course, there are other factors that would be particular to the individual case, such as Commerce Commission didn't approve it for a public utility, etc. We talked about the requirement of making an offer. This is required before you can file your eminent domain case. The law calls it a bona fide attempt to agree. The statute now calls it a good faith attempt to agree with the owner on compensation prior to suit. Usually what happens is, when I'm representing public bodies, it always happens, that I require the public body to get an appraisal. The law does not necessarily require an appraisal, but it's going to be very difficult to show a good faith attempt to agree without an appraisal. The second thing I always advise public bodies is that they need to offer the full amount of the appraisal. A lot of times the public body gets the appraisal in and then get a little sticker shock. They go, whoa, this property isn't worth that much. I know what that property's worth. That property's not worth this. You can't, I counsel the public bodies. not to substitute their own judgment for the judgment of an independent appraisal. If that appraisal you think is too high, then get another appraiser. But I always counsel public bodies to make an offer in the full amount of the appraisal. Now, the law doesn't necessarily absolutely require that, but the law does require you to have a really good reason why you're not offering the full amount of the appraisal. And so typically today, public bodies always offer the amount of the appraisal. Public bodies have to keep the offer open for a reasonable time. You can't say, well, here's an offer, 3 days, you got 3 days, take it or leave it. And if it's taking by IDOT or some other state agency, there's a specific requirement that after they make the offer and there's no agreement, that they then give you a 60-day notice of an intent to file their action in eminent domain. So it's got to be open for a reasonable time so the property owner can consider it. And if a counteroffer is made by the property owner, the condemning authority is obligated to respond. And there's a case that says that the offer was made in writing, the counteroffer was made in writing, and then the public body never responded, just filed suit. Because the difference between what the owner was seeking in just compensation versus what the offer was not a wide difference in value. They were fairly close. The court said that the public body abused its discretion by not responding to the offer in writing, but simply filing the lawsuit. That was not found to be not a good faith attempt to agree. So when you file a traverse, traverse is similar to a 2619 motion to dismiss, but there are several key differences. Number one, a contested evidentiary hearing is normally required unless there is a stipulation as to certain facts. So you have an evidentiary hearing where you have to put on evidence in front of the judge. In such a hearing, the burden is on the public body to show its right to take if that's being challenged. The public body usually can put in an enabling ordinance, or IDOT uses its power of eminent domain and shows what the plans are for the proposed project to show its prima facie right to exercise eminent domain. An enabling ordinance is a prima facie showing of the right to acquire the property. If there is a challenge on the issue of necessity, saying you don't need all this land, you're acquiring too much land, that determination is normally one which is made by the public body, and the courts have held that determination is entitled to some deference, so that the owner would have to show an abuse of discretion in that enabling ordinance, which is difficult to show. If once there is a prima facie case established by the public body, then the owner must come forward with his or her evidence as to why the traverse should be granted. In other words, your evidence as to why there was not a good faith attempt to agree, or your evidence as to why there was, in fact, an abuse of discretion in this land is more lands being acquired than necessary. Or there is the public body doesn't have the right to take private land and give it to a private developer because it hasn't complied with the various aspects of the eminent domain code. So you would put on your evidence if you were representing the landowner as to why the traverse should be granted. Of course, the public body then would have a right to put on any rebuttal evidence, and then the court would rule. If the court denies the traverse, that is not a final and appealable order. You have to go through the case, determine the value, and then appeal it. I've had cases in which we haven't had a big difference in value with the public body, but that we didn't want to sell at all to the public body. So we challenged the taking. The judge sometimes rules against me. I know that's hard to believe, but sometimes judges rule against me. And the owner wants to appeal it. Well, we can't appeal it until we establish a value. So we work out a stipulation with the public body that says, look, if the appellate court affirms your right to take this property by eminent domain, here's the value we've agreed to accept. Enter that final order, and that now becomes an order that you can appeal to the appellate court, and then you can appeal the denial of the traverse. However, when I am successful, and I have been successful in a number of traverses, if the traverse is granted, then the eminent domain case gets dismissed, and the owner is entitled to all of the reasonable attorney's fees that it incurred in defending the eminent domain action. Now there is a provision in the Illinois eminent domain called quick take. Quick take is the power of certain public bodies to acquire the possession and title while the eminent domain case is still pending to determine the amount of final and just compensation. What happens is you have a hearing in front of the judge, and the statute requires that the plaintiff must make a prima facie case that has the right to acquire the property, the use of quick take procedures necessary. Why do you need title now? Example is roads. IDOT has quick take power, and a lot of times exercises that power because he wants to construct the roads while the eminent domain case is still pending. Otherwise, a public body would have to wait till the very end of the case when the just compensation is determined. And if there was an appeal, wait until the appeal is over before it could take title. And so the statute gives them the right to acquire title by paying what's called preliminary just compensation. They put on an appraiser, testifies to what the compensation is. The owner has the right to put his evidence on. If he or she decides to challenge that amount, and the court determines the preliminary amount of just compensation. That just compensation gets deposited with the court, and the owner has the right to withdraw that. And then the public body then has title to the property. Case continues to pend to determine the final amount of just compensation, and the jury never hears about the preliminary amount. We've been talking about just compensation. How is it defined in Illinois? Illinois defines it as the fair market value of the property at its highest and best use on the date of the filing of the complaint. That has been the typical definition of just compensation. Fair market value is also defined, and which is what is commonly used in the real estate appraisal process under the sales approach, which is a price that a willing buyer would pay in cash and a willing seller would accept when a buyer is not compelled to buy and the seller is not compelled to sell. In other words, what would the property sell for on the open market between a willing buyer and a willing seller? Highest and best use. Highest and best use is that use which would give this property its highest market value on the date of the complaint being filed. It doesn't have to be the actual use of the property. It can be a use which, if it was reasonably anticipated in the foreseeable future, the property would have to be valued at that use. For example, public bodies acquiring land for a road, and all of the land surrounding this house has been developed for industrial purposes, but the house has not yet been developed that way. The property would have a highest and best use of potential industrial development. And if that use gives it a higher market value than the value of the land as single family, the property have to be valued at that highest and best use. Now, we talked about the date of value being the date of the filing of the complaint. That historically, for 35 years of my 40 years of practicing, or something like that, it's always been the date the complaint was filed. But now, under Section 10560 of the Eminent Domain Act, if it's been more than 2 years from the date of the filing to the date of the actual trial, and if the value has changed substantially between those two dates, has appreciated in value, the owner can request that a new valuation date be established by the judge. Now, I'm talking about just compensation. You don't get loss of business. You don't get settlemental value. You don't get your attorney's fees, usually. It's just what the value of the real estate is. When we try an eminent domain case, there are, of course, a number of pretrial motions that are filed, usually challenging some of the basis upon which the appraiser has rendered his opinions. There also can be a question of the right to open and close. If the property owner is claiming damage to the remainder, which we'll talk about in a minute, the owner has the burden of proof to prove that. So the owner would have the right to open and close in the case. The view of the property. Almost always, one of the parties requests a view of the property, and that's when you put a jury on a bus, drive them out to the property, and the jury looks at the property, and that becomes part of the evidence in the case. When an owner testifies, a lot of times the owner wants to testify to value, and it's challenged that the owner isn't an appraiser or is not in the real estate business. That's not the law in Illinois. The owner has to show just any kind of knowledge of the real estate market in the area of his property. That owner is going to be allowed to express an opinion of value. And then, of course, you would have appraiser testimony. And you might have testimony from other experts as well, such as land planners or other experts. How am I doing that? Okay. Valuation. The calculation of fair market value in Illinois, there are some specific rules, and that you need to be familiar with them if you're going to handle an eminent domain case. Real estate appraisers are now considered expert witnesses. At one time, they were not, surprisingly enough. But now they are, and they can use the market approach to value, which is the standard approach, which is the approach which Illinois courts have approved. Illinois courts frown upon the cost approach, and you cannot use the cost approach as a primary approach to value. The cost approach is where you add the depreciated property of the building to the value of the land to come up with a value. Illinois courts have routinely held the property value is not subject to such mathematical certainty. That seems to suggest to the jury some sort of mathematical certainty in valuation, and Illinois courts have disapproved of that. The income approach is used a lot of time by appraisers to evaluate office buildings and other income-producing properties. The problem is that Illinois doesn't recognize that, again, as a primary approach to value. You can use the income approach as a check. They call it check the value, which makes it interesting because when you try the case in front of the jury, You put on the appraiser, he testifies to the market approach. Did you use another approach to check that? Yes, I did. What'd you use? I used the income approach. And then he tries to describe his income approach, and there's an objection. Some courts have allowed that testimony to come in with a limiting instruction that says this is only to be considered as a check on the market approach, not considered an independent approach to the value. Other judges have not let the appraisers testify to any of the details of the income approach, other than its basic conclusions. The judge is the gatekeeper on real estate appraisers and other experts. Real estate appraisers are now allowed to rely upon evidence that they normally would rely upon in their real estate practice, such as comparable sales. It used to be appraisers couldn't testify to the value, the specific value of the comparable sales. You had to put the comparable sales in evidence and then had the appraiser discuss them. Now, of course, under the case of the Department of Transportation versus Beeston, which was a case handled by my office, the courts held that the federal rules of evidence do apply, and experts are now allowed to rely upon information that's not necessarily admitted in evidence. But what happens now in Illinois is that under City of Chicago versus Anthony, an appraiser can't use, the federal rules to try to rely upon information that would be substantively inadmissible in an eminent domain case, such as, for example, the owner got an offer, and the court ruled that offer was not admissible. Well, the appraiser couldn't rely upon that offer in his opinion. You also have the unit rule in Illinois. The unit rule provides that you must value the property as a whole. So if there's a partial taking, you have to first value the whole property, and then you have to value the part taken as part of the whole. You can't value it as a separate piece of property. You also have issues concerning if there was a recent sale of the subject property. Sometimes it's usually being used by the public body to establish value. The owner will sometimes object to the sale, saying, I've improved the property. I've done this, I've done that. It's not representative of the value anymore. Or it's too old. It was a sale 5 years, 6 years ago. It shouldn't be used. And the court would have to decide whether the sale of the subject property would be admissible or able to be relied upon by the appraisers. Offers to purchase can be used, but there's very specific rules as to when and how offers can be used. We've discussed a little bit about the concept of damage to the remainder. The owner is entitled to not just the compensation for the part that's being taken, for part of his land that's being taken. The owner also is entitled to the depreciation in value of his remaining property caused by the taking. So, for example, if the owner has a sign, it's going to have to relocate the sign. Well, that's a cost that he's incurring as a result of the taking. He's entitled to be compensated for that. The property is being reduced in size, and is now the utility of the property is reduced. Again, the courts have held that's a proper factor. I've got plans for my real estate. I was going to develop it into this big shopping center, and now I can't as a result of this taking. Again, certain situations, those plans would be admissible, and for explaining to the jury what the damage to the remainder actually is. You also have issues of access, and this is a complex area of eminent domain law. There are cases on both sides of the issue as to whether an impairment of access is compensable. If it's a minor impact that, for example, medians typically are not compensable. You can't say, well, I can't turn left anymore out of my property. Courts have held, well, that median is really for the public benefit. and any incidental loss to you is not part of what would be damage to the remainder. So a sample formula for appraiser testimony and for virtually any testimony in an eminent domain case where there's a partial taking, the, the appraiser must go through these steps. And this is a sample. So the appraiser establishes the fair market value of the entire property at its highest and best use, either an actual use or a use which could be anticipated. And there was the concept then of reasonable probability. I want to value this property commercial because I've got commercial adjacent to me, but I'm zoned single family. How do I do that? The appraiser then would use the concept of reasonable probability of rezoning, saying that on the date of value, it was reasonably probable that the property could be rezoned. So the appraiser establishes the fair market value of the whole property. He then establishes the fair market value of the part taken as part of the whole, remember. And then he just subtracts those two numbers to get the fair market value of the remainder before the taking. Then the appraiser determines what is the fair market value of the remainder after the taking. So how is it affected by the taking? How is its value is affected? The appraiser establishes that value. And then to get the damages to the remainder, again, that's a subtraction from the value of the remainder before, subtracting the value of the remainder after to come up with the damages to the remainder. So in this example, the owner would be entitled to just compensation in the amount of the part taken of $100,000 and damages to the remainder of $150,000 for a total just compensation of $250,000. I think I'm about out of time, right, Amy?
Yep, we're just got a couple minutes left, and we do have a couple of questions that have come in.
Okay.
So thank you, Joe, for going through that deck. Remember, everyone watching, that Joe and the rest of our litigation team are here to help you navigate the complexities of these types of laws. So since we do have time for a couple of questions, we'll dive right in. We have a question here, Joe. Do municipal park districts generally have condemnation power? If the town is home rule, does that automatically apply to the park district?
Park districts generally do have the power of eminent domain granted to them by the legislature. There's usually a specific part of the park district statute that enables them to do that for park purposes. Home rule would only be applicable to municipalities. Home rule would not be applicable to park districts. Home rule municipalities still, if they're going to exercise the power of the domain, still have to have a specific grant from the legislature to do that.
Great. And we got time for one more question. Does a tenant on the property to be acquired have any rights?
Yeah, that's a good question. And the answer to that is yes. A tenant can make a claim for compensation if he's got a benefit in his leasehold interest. In other words, he's got 5 years left on his lease. He's paying, $50,000 a year. But the least comparable property after the taking, he's going to have to go out and lease property for $75,000 a year. He has suffered a loss of $25,000 a year, which would then have to be reduced to a present cash value. But that then can make a claim in the eminent domain case for that compensation.
All right, we're right at 12:45, so that wraps it up for today. We hope that that was an informative session for all of you listening. We thank you for attending. You can contact Joe directly if you have any additional questions. I put up his contact info on the screen, and we're happy to answer them offline. Have a great rest of your day.
Thank you.